Does everybody who appeals a trial court decision get the opportunity to argue and actually do the whole appeal? Is that a right? And tell me about, does every person get the chance to do it?
So certainly it depends on the jurisdiction. And I know that we're talking about Missouri here. So the Western District, which is where I practice, pretty much will take any appeal as long as there is a colorable claim, as long as there's something that could be that could have a different interpretation below. So, and you asked about arguing. There's one chance to argue, and that's at oral argument. And oral argument is very, it's sort of the last ditch effort, because you can't say anything in oral argument that you have not brought up in a brief. So everything has to be already discussed in your briefs. So the Court of Appeals is actually very kind and generous in Missouri. They will, when I was practicing in New York, you have to beg for oral argument. So once the briefs are all submitted in Missouri, if the court determines that it doesn't need to hear from the attorneys on any of this, the Court of Appeals will send basically the "we don't want to see you" letter, but it's much nicer than that. It's we've determined that this case can be resolved without the benefit of, we don't need oral argument, and then any party who wants oral argument has 10 days to request oral argument from that point. And then they will, if you request it, then it gets scheduled. That's in the Western District. I don't really know about the Southern and Eastern, although I would imagine the process is similar.
When a client comes to you to talk about an appeal, what would you say about the timeline of an appeal? And yes, we're sticking to Missouri, and we can extrapolate to Kansas and federal later. Well,
what I tell them is that it's a lot of hurry up and wait, and then once you get on the train, it goes, and that's it. So again, so custody cases actually there are certain cases that are expedited that have less, that go faster, and custody is one of them. But for the majority of cases, in Missouri, a judgment is final 30 days after it is entered. So frequently I'll get calls and it's after the 30-day period. And at that point, so between 30 days so after the judgment's final, the parties have 10 more days to file a notice of appeal. So it's really 40 days since the day the judgment is entered. And there are circumstances under which the Court of Appeals will permit late notices of appeal, but I've done it before. The Court of Appeals will do it, but it requires a special, it's an application for special permission to file late notice of appeal. So it's just more work to do it. So the notice of appeal gets filed in the circuit court, and then that is sent to the Court of Appeals. And then from the date of the notice of appeal, the appellant has 90 days to get the record on appeal together. And the record on appeal is the legal file, which is all of the documents that were filed in the circuit court. Well, not all of them, the relevant documents that were filed in the circuit court. And that's actually a whole different, it's become super easy to do that. And the transcript, the 90 days is really so that the transcript folks can get it done, because that takes a long time. And sometimes they get it done fast, and the transcript organization is straight out of St. Joseph, so depends on their load and what have you. So after that 90-day period, then the appellant's brief is due 60 days after that. The respondent's brief is due 30 days after the appellant's brief, and then the appellant gets a reply brief 15 days after that. And usually people ask for at least one, maybe two extensions of time for the same period of time. So I usually tell people it's a year from the date of deciding to appeal until it's resolved. I've had really good, it also depends on when the court schedules oral argument. I had one oral argument that was scheduled in May, even though we had finished all the briefing in December. So it was a long time later. But generally speaking, the Court of Appeals, once they get it, I have found that they issue the decision fairly quickly. much faster than circuit court decisions in some ways, because they're very scheduled with how many they take in a given time period. So that's usually what I tell people as far as time frame. But frequently what happens in terms of costs is that I'll enter a notice of appearance and then nothing happens for a while, because we have that 90-day period and then we have another 60-day period, and then all of a sudden it's boom, 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 and that's all I work on.
When you are writing your appeal on behalf of your client, what all is going into that? Do the facts matter in an appeal as much as the law, or is it a combination of both?
It's definitely a combination. And it also depends, again, it depends on the standard of review, right? So if I'm dealing with an abuse of discretion standard, which is most of them anyway, but that's most appeals, because more people are going to say, hey, I don't like what happened. Not, I think the law is wrong. Not, even though we would love to have it, not every case is Brown versus Board of Education, right? Not every case is separate but equal, or, ending Jim Crow or something, or a Obergefell, which is the gay marriage, like all that amazing stuff. We might get like a touch of that, but it's not, it's most of it is like, I don't like what happened. Right. So, Missouri has very specific rules about how to structure the brief, as do most states and the federal courts. So the statement of facts comes first, and you can't argue the statement of facts. So, but again, it's one of those skills where even though you're not arguing about what happened, like you can't say, I'm just thinking, you can't say the court wrongly did X, Y, and Z. That's for the court incorrectly ruled that blah. That's argument. You can't do that. So that's a blatant form of it. But there are ways to structure the facts, which we've all learned in law school as well, like start out with your good facts, put your, like, kind of hide the bad facts in within paragraphs, or try to minimize them by placing them in certain parts of the brief, but you have to show the fact, in Missouri, you have to show facts that give the court a complete and accurate understanding of what happened. So that's the rule, essentially. And people mess with that all the time, actually. And usually that happens, by people, I mean attorneys who write it, or try to either skew it, or what happens frequently is omission of facts, because it's easier to omit bad facts than it is to characterize bad facts as good facts or hide them. But that's not okay either. But people do it all the time. So, all right. So that's the facts section. So yes, it matters, because that's actually the first thing they read, right? Is they're like, here is not always. So in Missouri, you have these awful things called points relied on. You remember points relied on?
I've tried to banish it from my memory.
Well, I never liked the concept because basically they're point headings of the points that you're going to make in your argument. But points relied on, I'm thinking, like, why are we ending that phrase with a preposition? It makes me crazy. But Missouri, I'm like, how could there be a thing called points relied on? That's what we're going to call it. But okay, never mind. So, and essentially there are rules for doing the points relied on. It's kind of like under does when in law school, we say, like, under this law, does the trial court correctly rule for the petitioner when X, Y, and Z happens, as in fact. So what they're trying to say is in the points relied on is, according to the law, how did the trial court do it wrong and why? So it's basically including all of your arguments within your points. So the first thing the court's going to read is your points relied on. Then, so they know what your arguments are. Then there's the statement of facts, and they read that. Then they're going to read the points relied on with the argument attached. So you have to in a brief, you have to put the points relied on twice. So you have to put it first, well, the facts, then the points relied on, then the argument. But it's all there anyway. So then by the time you get to the argument, you're saying, okay, here's the standard of review, and here's why the lower court did either the right thing, like, so we'd say the trial court erred in determining blah, 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 or we do the right, or we say the court of appeals the lower court did the right thing, did the the wrong thing, the court erred, or sorry, or when I get animated, or did the right thing, as in the court below correctly held law. So, and then, people tend to put in the kitchen sink, and it's interesting because it's my belief that really you should only include in your argument points that your best points, and let the rest of it go. They don't want to read an 8-point brief.